Hear ye, hear ye, hear ye. The Honorable Chief Justice and Justices of the Supreme Court of Ohio. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning. Our first case is 20-92, the State of Ohio, ex rel. Dave Yost, Ohio Attorney General versus Volkswagen Group and/or Volkswagen AG et al. I should take note that Judge Delaney from the 5th District is sitting in place of Judge Bruner, or Justice Bruner, this morning. Welcome, Judge. All right, we will start with the appellant, Mr. Giffra.
Thank you very much, Your Honor. Good morning. Robert Giffra with Sullivan and Cromwell for the Volkswagen defendants. I'd like to reserve 3 minutes for rebuttal. Your Honors, we believe the court should reverse the 10th District because the Clean Air Act's text, structure, and enforcement history support preemption here. Starting in 1967, Congress imposed a whole series of standards governing manufacturers with respect to auto emissions and gave the EPA the key role in that process, the exclusive role with respect to the regulation of manufacturers with respect to standards for auto emissions. And that makes sense because you want a car when it's built and over its useful life to be compliant. Until now, there's never been a state claim under a tampering law against manufacturer, even though General Motors, Ford, Chrysler have all had defeat device issues. And under the state's theory, there are literally no limits on what the states can do with respect to post-sale conduct by manufacturers, notwithstanding the fact that the Clean Air Act has all of these standards governing manufacturers. So under the Clean Air Act, a manufacturer must meet Clean Air Act requirements over the useful life of a vehicle. That's in 42 U.S.C. 7521. A manufacturer must seek approval from the EPA in order to change its emission system post-sale. A manufacturer must provide a warranty to customers, and those warranties are regulated post-sale by the EPA. Only manufacturers, only the EPA is authorized under the Clean Air Act to require manufacturers to test their cars. In fact, there's a specific provision in the Clean Air Act, Section 7541 H2, which expressly bars states from requiring manufacturers to test their cars post-sale. In addition, in terms of doing a recall, only the EPA can require a manufacturer to do a recall.
Counsel, is the state of Ohio trying to do any of those things that you just mentioned? Are they trying to reconfigure the programming of an aftermarket vehicle? Are they trying to establish different standards for those vehicles initially? Are they deviating from whatever the updates will be offered that the manufacturer has cleared with the federal government? Has any of that taken place here?
Yes, what the state of Ohio would like to do is regulate and impose substantial penalties, literally $350 million a day, against Volkswagen for conduct that is governed by the Clean Air Act. So that if Volkswagen does something in terms of updating its system post-sale, the Clean Air Act specifically provides that Congress, that the EPA shall have authority. There are provisions for penalizing manufacturers who violate those requirements. And until now,
Counsel, how would Ohio be made whole under that scheme?
Ohio has already been made whole. In fact, Your Honor, under the existing scheme that's been put forward, the state of Ohio has received $414 million from Volkswagen. It has received $33,000 per car, probably the value of the car, for the 14,000 vehicles that are in Ohio. And that was all done pursuant to settlements that were reached by the EPA exercising its comprehensive authority. And I would urge the court to look at pages 13 to 15 of our brief, which list out all the standards. Now, in terms of the alternative here would be regulatory chaos, because cars cross state lines. And the error that was made below was the concept of a power plant, which is in a state and pollutes. That's different than automobiles. And starting again in 67, Congress set forward this comprehensive scheme regulating auto emissions. Now, in terms of how to interpret the statute, there's a provision, Section 209A.
Before you get there, Counselor, let me ask you. I'm having a little hard time understanding what exactly your argument is. Is it that the state can't regulate this because it's a manufacturer who's tampering, or because it's done on a large scale basis?
Your Honor,
clearly the state can regulate someone who alters their catalytic converter, or someone repair shop. So why is a manufacturer different?
There's no question that under the Clean Air Act and the regulatory structure contemplates that with respect to mechanics, individual automatic manufacturer, individual owners, that the state can use its tampering laws. There are no provisions in the Clean Air Act providing that states can regulate manufacturers, and it hasn't been done for literally 50 years. And if you look at Section 209A...
So if a manufacturer tampered with one car, would the state be able to regulate that?
I think if a manufacturer, say if the manufacturer did it, but if
Volkswagen did it, if Volkswagen directed one dealer to alter the emission system,
I think that would probably not be allowed, but it certainly would be a closer case than the case here, where what happened was Volkswagen, there's no question, had a defeat device in the vehicles, changed how it was, slightly changed the configuration of the defeat device in the cars that were being sold as they were being sold, and then went back.
So I'm just trying to understand what the distinction is here. So the distinction is that because someone's a manufacturer, that a different set of standards apply than to someone else.
Well, that's because the Clean Air Act has multiple provisions governing manufacturers. So, for example, there are provisions saying that there are a lot of provisions
about manufacturers, but the provision I think that's at issue here is about new automobiles.
I think, Your Honor, the way I would think about it is 2 points. One would be with respect to a recall, the Clean Air Act specifies if you have 25 or more cars, that's governed by the EPA. So when you're hypothetical about one, there's actually a provision in the statute that addresses that. Number two, under 209A, it says no state or political subdivision shall attempt to enforce any standard broadly defined relating to the control of emissions from new motor vehicles. What the state does is focuses just on the word new motor vehicle, same mistake that was made by the 10th District, ignoring the word standards, all the standards that are specified in the statute, as well as
we just take new motor vehicles out of the statute? I mean, what's the point of new motor vehicles under your theory then?
Well, because what happens is the software updates that were done here relate directly to the factory installed defeat device that was in the vehicle. It was an update of it.
Every change is going to relate to something that was installed during manufacturing.
Exactly. And Congress specifically provided in the statute that the EPA would regulate that process. And there's nothing in the statute that provides for states to do so. In fact, states can't require expressly, under the provision I cited before, any sort of testing of manufacturers. The word related.
Isn't that the wrong question? You say there's nothing that provides for states to do so, but isn't the question whether anything in the statutory scheme precludes states from doing so, or are there any part of federal law that conflicts with states doing so?
Yes, Section 209A by its terms says that if a state wants to attempt to enforce a standard, and these standards that I discussed before, including the recall standards, the update review standards, all giving exclusive control to the EPA, the state cannot be involved. And relating to, the Supreme Court has said, has broad preemptive purpose. It's something that preempts a large area of federal law. And Your Honor, we would urge you to look at the Supreme Court's decision by Justice Scalia in South Coast. That's in that case, Justice Scalia and the case is 541 U.S. 246. Justice Scalia, in determining, it's the only Supreme Court case dealing with the preemptive scope of Section 209A. Justice Scalia looked at how the statute, what powers did the statute give to the EPA to determine the scope of preemption? What were the standards of enforcement? And in that case, Justice Scalia said, well, and Justice Souter dissented, applying a presumption against preemption. And Justice Scalia said, no, a standard is a standard. You've got to look at all the statutory standards, including the ones I listed at the beginning of my argument. And he said that those standards provide the scope of the preemption. So 209A is critical. Now, what the other side does, again, is just focus on the word new, but ignores relating to and ignores standards. And a textualist doesn't look at just one word, put on blinders. You have to look at the entire phrase. Now, the other side will look at, they cite a provision 209D, which preserves state and local authority with respect to the use, operation, and movement of a registered licensed vehicle. And there's no question that with respect to an auto mechanic, the states have control, and that's reflected in EPA regulations. EPA regulations, which we cite at page 28, longstanding regulations, make it quite clear that there is no such authority. But what the other side does is it takes the word operation and misuses a dictionary definition. A textualist analysis would look at the words use, operation, and movement to mean driving a car. And that's consistent with federal law. It's consistent with state law that the word operation means driving a car. And that's clearly that. And there's a DC Circuit case, engine manufacturers, which says that 209D covers things like state restrictions dealing with car lanes and things like that. So we believe there's express preemption here. We believe there's conflict preemption here because there is a comprehensive federal scheme and all of these provisions, which the state ignores, that clearly give the EPA the exclusive power to regulate manufacturers, and any other approach would lead to regulatory chaos. I'll reserve the rest of my time.
Thank you. Mr. Hendershot.
Chief Justice O'Connor, and may it please the court, as the Supreme Court reminded just last year in Kansas versus Garcia, all questions of preemption, express, implied, whatever label is put on it, must be grounded in the text. And that's the problem for Volkswagen here. As you just heard my friend talk about some of the distinctions that they're trying to draw in the statute that simply are not there. I think you heard him say that everything would relate back to the car and to their theory of relation to. Anything you do to a car, even the single mechanic, even the owner working on that car, of course, relates to, in the broadest possible sense, to the car that came off the factory line in Chattanooga or Wolfsburg. So that theory of relate to is not consistent, as my friend urges you to do, to look at the statute as a whole. You also, I think, heard him my friend struggle to distinguish how would a mechanic be treated differently from a manufacturer. There's simply nothing in the statute in the relevant parts here, the federal anti-tampering statute, the state anti-tampering statute, that distinguish those. It is any person, the owner, the dealer, the mechanic, the manufacturer, that engages in this distinct act. And remember, let's connect theory to fact here. Remember what Ohio is seeking to penalize here. It is the distinct act of Volkswagen, after these cars were in the garages and driveways of Ohio, of reaching back under the hood, changing these cars to make them worse than when they came off the factory line. Now, my friend...
Counsel, do you agree with opposing counsel that the state of Ohio has already been made whole here in this case?
No, Your Honor. I would point to two things. But number one, the settlements in the federal court, and we cite these on page 40 of our brief, citing to the documents in the federal district court that lay this out. The settlements specifically reserved to the states the ability to seek fines and penalties. What Ohio is seeking to do here is to vindicate its environmental laws that protect Ohioans and Ohio's environment. And so if Volkswagen and its army of lawyers and the federal government thought that none of these actions should be allowed, then that settlement could have tried to block all of these actions. It specifically reserved the criminal and then the civil fines and penalties. You can see that we haven't talked much about what the Ninth Circuit did in this case. It unanimously rejected all of the same arguments that Volkswagen is trying to sell you on here today. It pointed out just what I'm mentioning here in terms of the settlement, that is something that is specifically reserved for the states to be able to pursue.
Counselor, would there have to be some sort of set off? Wouldn't Volkswagen be double penalized?
Well, no, Your Honor. They would not be double penalized in terms of the fines and penalties that have been specifically reserved by the settlement. But remember, and I think the question does raise this important point, that we're here on a motion to dismiss. The trial court closed the door entirely on this action. Volkswagen can make all the arguments it wants in terms of the setting the penalties. And I can tell you, not only would the Ohio EPA, but of course the judges, after some fine was levied, would have the ability, and they do this in the agency, I can tell you, they look at what has this person, what is this defendant in front of us, have they paid in other states, to the federal government? That would certainly be part of the calculus, but we're not here arguing about $350 million a day. We're here saying the 10th district was correct to at least crack the door back open and let Ohio's litigation proceed so that it may seek those fines and penalties. But that's a back-end question as to whether there are any issues to sew up if the fine was exorbitant, if that's where we ended up. But here, we're defending an appellate judgment that opened the door back up for our action to proceed. Now, something else I wanted to touch on that my friend mentioned was to focus on the word relate to, and the U.S. Supreme Court has said it is a broad concept. Fair enough, but take a look at what the U.S. Supreme Court said most recently about relate to. This is in the Rutledge decision that we submitted as supplemental authority. There, the court said relate to is not endlessly expansive. It tolerated, it did not preempt an Arkansas statute, and it said, this is the slip opinion at page 8, state-to-state variation is not something that automatically leads to preemption. Relate to is not some kind of all-purpose preemption provision.
What about opposing counsel's point here that these a manufacturer is maybe updating their software on a fairly regular basis. So maybe updating software relating to admission systems. And I assume as technology keeps moving forward, you're going to see more and more of that kind of changes. I mean, does that really fall within the purview of tampering under the statute?
Well, it depends on what is done, Your Honor. I think the key here for this case is all the concerns that the chamber raises and the Volkswagen raises about, you heard my friend say it, regulatory chaos, you can put to the side right now. And that's because in this case, there is exact parallelism between what the federal government is doing and Ohio is doing. The federal government called this criminal. Ohio is seeking to penalize it. If you have a situation where the federal government gives the thumbs up to some kind of update and a state tries to do the opposite, you would have a different case. And that's not just me saying that. The Supreme Court made that exact point in the Buckman decision. This is at page 354. And they said, different case if the federal government, so that was a Food and Drug Administration preemption. And there, the federal government had approved something that state law was trying to disapprove.
Well, would the federal government ordinarily approve an update to the software on emissions?
I think ordinarily not. There are provisions. There are things like the memoranda written in the 70s and later that it depends on what is being done. Now, again, we're at the motion to dismiss stage, but what I can tell you that we have learned from other litigation around the country is there are multiple steps to Volkswagen's act of cheating that Ohio is trying to regulate here. Initially, it was letters to customers. Again, this is not in the record here. I'm just telling you what we would probably look into in discovery. There were letters to customers, bring your car back in. We want to change something about it. Then Volkswagen engaged in a voluntary recall. At one point, they told the EPA, yes, we're recalling these cars to fix something. Of course, that was a lie that was something that Volkswagen tried to hide for years. But again, that approval, the federal government wanted to learn the truth, didn't approve of this, like in those conflict preemption cases like Buckman and Arizona versus the United States. The federal government said, no, this is a criminal act. And Ohio agrees. So when a federal and state law run in parallel, they don't even have to be perfectly in parallel, as Kansas versus Garcia emphasized. When they run in parallel, you have a different case, as the Supreme Court said in Buckman. You have the conflict between the federal government approving, take a look at Arizona versus the United States. The federal government wanted to decriminalize what Arizona wanted to criminalize. There's nothing like that here. Those are different cases if you end up with approval by the federal government and an attempted disapproval by the state. My friend also.
Let me ask you about your savings clause argument. As I look at that language, control, regulate, restrict, movement, it seems pretty clear to me that operation means something similar. And, so I don't find that very persuasive, nor do I find the Ninth Circuit's analysis on that very persuasive. Does your argument depend on that?
2 points, John. It doesn't depend on it for this reason. And then I'll make a textual point as well. It doesn't depend on it because remember what preemption is the federal government elbowing aside the state's government. It is not a matter of that we must come within the language of the savings clause to be able to regulate here. Instead, it's the opposite. Volkswagen must show that the federal government has explicitly or by implied conflicts or something pushed the state government aside. So we don't need to come within the language of the savings statute to be able to pursue this case. But textually, it is not just the word operate, it is control the operation of. And what Ohio's tampering statute does is say, you may not tamper with a vehicle, then you may not operate a vehicle that has been tampered with. And so it is control. Saying don't tamper with emission systems is a way of saying don't operate these vehicles around the state that are releasing more pollution because somebody has tried to bypass the emission system. But I think the most important point there is that we don't need to be in the savings clause in order to save the lawsuit here, because that's just not the way the preemption works. You can look at the Ninth Circuit, you may not find their dictionary definition persuasive, but take a look at footnote 23, where they made the same point I'm making here about Volkswagen having preemption upside down by saying you must fit within the savings clause. It's the opposite. Volkswagen must show that our action has been pushed aside and entirely blocked by federal law. And my friend encouraged you to look at Justice Scalia's opinion in the Engine Manufacturers Association case to South Coast. And while there, the court did find preemption, look at the analysis that Justice Scalia went through. That what he criticized is what Volkswagen is asking you to do, which is engraft a manufacturer versus mechanic line that is not there. Lump together statutes that don't deal with each other. Those are the exact problems with Volkswagen's argument. You heard them try to distinguish mechanics from manufacturers. There's no trace, to borrow the Supreme Court's language from Garcia, of that distinction in the statute. The anti-tampering provision in Ohio, the anti-tampering provision in federal law simply doesn't distinguish between those. When Volkswagen stepped out of its role as a manufacturer and was really just a mechanic writ large, it then subjected itself to the same prohibitions that mechanics would be subjected to. What if you had the major Volkswagen dealerships in Ohio doing the same thing Volkswagen did here? My friend told you they would be subject to regulation. There's nothing different here. All of the statutes about the original certification and guaranteeing that the original certification of cars and engines holds true for the life of the vehicle don't deal with the distinct prohibition on reaching back under the hood of cars that are on the road and in the driveways to make them worse when they came off the factory line. That is all that Ohio is regulating here. Nothing about original changes that were made on the factory floor. That's what the federal government has gone after and penalized. Now, they've also gone after what Ohio is here, as we talked about with Justice Stewart. But there's that distinct act that Volkswagen engaged in that Ohio is after here, reaching back under the hood of cars long on the road, sometimes for years in Ohio.
Do these changes make them worse than when they came off the assembly line? I mean,
They made them worse.
To me, the problem was when they came off the assembly line, these changes just help hide it.
Well, so it made them worse in this sense. They made the cars more polluting because they enabled cars that were the cars were never designed when they came off the assembly line to drive around in what we've called in the brief the clean mode, the non-polluting mode. And so the distinct act of cheating that Ohio is trying to penalize here was reaching back under the hood, enabling the car to run dirty more often and for more miles. And that's where it is worse from the laws we're concerned about here. Number one, the environmental laws, but also, of course, consumers who thought they were buying what Volkswagen called a clean diesel vehicle and made it even less clean when they reached back under the hood, the actions that Ohio is seeking to regulate here. Now, one thing my friend has pointed you to, I think, perhaps encapsulate the major problem here. He says, look at the enforcement history. There hasn't been something like this in the 50-year history of the Clean Air Act. Well, enforcement history is not, as the Supreme Court tells us we must do, grounding something in the text. It is sort of, preemption must be in there somewhere because it makes sense. That is an argument divorced from the text. And let me make this point then, Your Honor. If we look at the courts around the country, we've talked about the Ninth Circuit a little bit, which unanimously rejected Volkswagen's argument. Not a single appellate or federal court that we're aware of has accepted Volkswagen's express preemption arguments. And with the Ninth Circuit's reversal of the federal district court in California, you have because the states that relied on that for implied preemption all relied on the federal district court that has been reversed. So really, when you look around the country, there's nothing left in terms of courts supporting either of Volkswagen's arguments here. At bottom, then, Your Honor, Volkswagen's argument comes down to, well, there could be regulatory chaos if the facts were different, if something happens differently in the future. That's not this case. The Supreme Court has said that's not the kind of case this is. There is no cheating on a grand scale exception to the anti-tampering statute in Ohio. When Volkswagen reached under the hoods again and made these vehicles worse, that is something that Ohio may still regulate, just as the settlement preserved in the federal courts. Your Honor, if there are no further questions, I would yield the remainder of the time, and we ask that you affirm the 10th District.
Mr. Hendershot, before you leave, your friend on the other side indicated that the Clean Air Act has a specific provision that excludes manufacturers because it only really targets or allows states to go after mechanics or individual owners. What do you say to that?
I'm going to ask you to take a look at the federal prohibition on anti-tampering, which is just like the state one. It says any person. So just like the state law, covers mechanics, dealers, and manufacturers. The provisions that deal with manufacturers in their role as manufacturers of new vehicles and new motor vehicle engines, which is why the express preemption clause deals with new motor vehicles and new motor vehicle engines. But the anti-tampering statute reaches everybody, just like Ohio's. But there's certainly no carve out. And this is what I mean when I say they're not grounding this argument in the text. They are, as Justice Scalia said in the South Coast decision, lumping together unrelated statutes to offer an argument as well, because manufacturers have all these other obligations, they must not have this obligation that they do under the plain text of the anti-tampering part of federal law.
The other thing that your friend on the other side would say is that a manufacturer is required under the federal guidelines, under the regulations, to make modifications or to do updates to bring their vehicles into compliance with federal specifications. They are not, as you say, a mechanic at large. That as a manufacturer, they're required to do something that the EPA through Congress is requiring them to do. What do you say about that?
What I say is those are distinct roles. I think when they have these obligations that flow from building the new engine, all these statutes that my friend is talking about are tied to the obligations to certify that a new engine will not become polluting over its useful life. You can avoid any of the problems that Volkswagen could avoid Ohio regulation here if it didn't take a distinct second act, reaching back under the hood and acting like a mechanic. It's no different than if several mechanics got together and did what Volkswagen did here. So in that distinct role, that is why Volkswagen has put itself in the reach of Ohio's efforts to enforce its environmental laws.
Thank you.
Thank you, Your Honors.
Counsel for the state talked about unrelated statutes. This is a comprehensive statute that has a whole series of provisions that are interrelated, and they're laid out at pages 13 to 15 of our brief, that require manufacturers subject to EPA approval whenever they do an update to get that approval. 6 million updates are done every year, and they have to be done pursuant to EPA approval. The states under the statute have no role in that process. We agree that states can regulate mechanics and can regulate individual owners. There's nothing in the EPA, in the statute that says otherwise. Now, Justice DeWine hit it exactly right. The key part of the Ninth Circuit's decision is a 209D savings clause analysis. That is not a persuasive analysis for a textualist. When you look at the words together, it clearly means driving a car and doesn't give states writ large the ability to regulate the interstices of a vehicle. Here in Ohio says at paragraph 81 of its complaint that the update perpetuated, if not advanced, the original tampering that was done in the factory. That relates to, and 15 of the 21 judges who have looked at this question have agreed with Volkswagen. No question the Ninth Circuit disagreed, but the Ninth Circuit did. based on a selective dictionary game with respect to the interpretation of 209D. We think that Justice Scalia's approach in South Coast governs here, and you need to look at all of the provisions dealing with manufacturers post-sale. And that makes logical sense. You don't want a car to have an emission system that's compliant the second it's sold and then say, well, it doesn't matter after that. Congress specifically put in all these requirements, warranties, testing requirements. 25 or more cars have a problem, you've got to get EPA approval, and you've got to do an update. We could not have done these updates. Now, these updates were done subject to EPA approval. And in fact, if you look at the statement of facts in the criminal case at paragraph 141, these Volkswagen updates reduced emissions, and the state relies upon the state did not do its own testing because under the Clean Air Act, it couldn't do its own testing. So we believe that this is a case that's squarely governed by the Clean Air Act. There's never been a situation where a state has ever attempted to do that, and there have been other defeat devices, as I mentioned before. Now, let me say a word about the penalty regime, because I think this is something that is extremely important. Congress provided for a specific regime if a manufacturer violated the laws with updates, and provided for specific penalties of $25,000 per violation. What Ohio wants to do here is put in a penalty of $25,000 per day, which would be $350 million per day with 14,000 vehicles. And
Counsel, is that before us what the penalty is?
Yes, I think you have to take into account the fact that the penalty regime is provided for in the statute, this Clean Air Act. Congress actually has a penalty policy at 42 USC.
Was there preclusion states taking any further action once that federal settlement was negotiated?
What happened at that point in time was there had never been one of these cases. Ohio brought a case based on the original manufacturer tampering. Those cases were pending at the time of the settlement, and the government just said, okay, you can litigate the cases. We litigated all those original tampering cases. We won every one of them, and Ohio dropped its original tampering claim. They came up with the post-sale tampering claim afterward as a way to try to back into this. And so when you look at what happened here is that clearly the application of the Clean Air Act barred the claim, and the fact that it wasn't settled in a settlement, that EPA would have had to go out and get 50 states to agree to something when there was already pending litigation.
So the answer is that they weren't precluded from bringing this action.
They were able to bring the action, but they're subject to it was always subject to litigation, including the preemption provisions of the Clean Air Act. And the Clean Air Act could not be clearer that a state may not, under 209A, attempt to enforce any standard relating to, which my friend said was a broad term and encompasses a broad preemptive scope. And there's no question that in the statute itself, Congress specified all of these procedures and regulations governing updates of software on cars, and did so and gave all the exclusive power to the EPA, because whether to approve an update or not involves a lot of judgment. And as the Ohio Chamber in its amicus brief makes the point, it would impose substantial costs on consumers and manufacturers if 50 states could come and second guess everything. And in fact, Your Honor,
Counsel, you've used your time.
Okay, thank you. We urge the court to reverse. Thank you very much.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision. Okay, our next case is 2020-0031. Stilson Resources LLC versus the State of Ohio Public Works Commission et al. We have counsel here. Yes. All right. We'll start with the appellant. I'm presuming that's Mr. Walia. You have to unmute yourself, sir. There you go.
Good morning, Chief Justice, and may it please the court. Appellants will please reserve 5 minutes of our overall 15 minutes for rebuttal. My name is Manny Walia, and I'm the General Counsel for Appellant Siltstone Resources, a landowner in Ohio. In 2013, a company called the Guernsey Development Corporation did not receive authorization from the state before selling property to my client. My argument today, Your Honors, begins by answering this question. What is the legal consequence of that entity, the Guernsey Development Corporation's failure to receive authorization before selling property? In other words, what are the available damages to the state? The trial court concluded, and appellants agree, that the state would receive liquidated damages for its out-of-pocket losses. Its out-of-pocket losses are $430,000. The liquidated damages formula in this case would yield to the state $7.3 million. The state, however, says that not only can it receive the Hardy liquidated damages award, but it also has the ability to seek injunctive relief to unwind 13 transactions, all flowing from that instance of the Guernsey Development Corporation's first sale. Your Honors, this damages issue is an issue about statutory interpretation. Indeed, the state agrees. On page 28 of its brief, the state says that the General Assembly in statute RC 164.26, quote, implicitly conferred the power, end quote, of seeking injunctive relief to the state. Implicitly confers. Your Honors, respectfully, that is incorrect. That is wrong because the statute, any statute governing alienability or restrictions on property rights cannot allow for implicit conferences of power. To the contrary, the General Assembly must explicitly describe the state's powers. That test comes from this court. Recently, in 2000, this court in Symes said that a statute restraining alienation of private property, quote, should not be extended to include limitations not clearly described therein, end quote. Symes cited a case from this court from 1919 called State versus Dowden. In that case, the court used this clear language, quote, statutes which impose restrictions upon the use of private property, let me pause, exactly like we're talking about in this case. Let me continue with the quote. Those statutes, quote, will be strictly construed and their scope cannot be extended to include limitations not therein clearly prescribed, end quote. Your Honors, a statute regarding alienation or restrictions on property rights must be, according to this court's precedent for 101 years, strictly construed, and no limitations may be allowed unless they are clearly prescribed or clearly described. So what's the state's response on this key issue of statutory interpretation, Your Honors? The state does not address these cases. Nowhere in their brief does the state cite Symes, nor Moore versus Daubert, the 1919 case I mentioned. If we apply this basic bedrock statutory interpretation test, Your Honors, the conclusion will be clear. If we look at section 164.26, the key statute in question, which the state agrees, that statute does not have a single word about injunctive relief or equitable relief or rescission or any other sort of comparable, injunctive relief language. To the contrary, the section authored by the General Assembly provides a remedy for the exact situation that we're talking about here, where a party doesn't live up to its word. And the remedy that it provides is liquidated damages. In fact, the words say the commission must or shall have remedies regarding liquidated damages. Put simply, Your Honors, the statute at issue cannot clearly describe, that the state gets injunctive relief when it never uses those words at all.
Mr. Walia?
Yes.
Isn't the liquidated damages really more applicable to the administration of the grant?
It may be, Your Honor. We know that the statute talks about the commission being able to have policies for long-term control. And then we know that the legislature authored the ability for the state to get a remedy if the local government entity like the GDC here or Guernsey Development Corporation doesn't follow its word. So I think the statutory scheme notes that the injury is reparable, and notes that if the entity who received the grant money doesn't follow, the restrictions, the state can enforce by getting liquidated damages and its grant money back. The statute at issue would provide equitable relief only if it clearly described that, and it's
so your theory is even the restrictions on use couldn't be enforced.
No, Your Honor. Go
ahead.
I'm sorry to interrupt you. The trial court and the Court of Appeals both held that the use restriction regarding putting structures on the surface.
I understand that, but your theory seems to be that the legislature has no, or that the agency has no authority to put a deed restriction in unless it's provided for in the statute.
Not quite, Your Honor. The commission has the power to put restrictions on use of the surface, as it did. And as everyone in this case agrees, there's no disturbance of the surface. There's no structures being added to it.
There's no specific language in the statute giving them that authority.
That's correct. The use restriction flows from the long-term control, and there's no contention. No one disagrees with that. There's nothing happening on the surface. The point that I'm making...
Well, I'm just trying to reconcile your statement, that statement, with your statement that the agency can't do anything unless it's specifically authorized to do so, as far as putting deed restrictions.
The key difference, Your Honor, if I may, is that the restriction here is on alienability. It is about the future use of the property, it's about the sale of the property, the conveyance, and that has a specific sort of respect in this state, going back to 1919. Anytime that the government is trying to tell individuals or entities what they can do in terms of selling, there are special rules going back to 1919 saying that the legislature must clearly describe those. So that's the key difference. The use restriction is not per se an alienability or a transfer of property restriction. And no one disagrees with the state's view there. We're all in agreement, the trial court and the Court of Appeals. The only disagreement that remains in the case is what to do about that clause 4 in the deed. It's called the deed restrictions or transfer, and that's the alienability question. To conclude here, the legislature did not provide a single word regarding equitable relief, and therefore it cannot meet the standard of clearly describing that restraint. In addition, I will note that the legislature does know how to do this, because in this same chapter, chapter 164, in a section regarding bonds, which is not at issue here, but in that section, which is called 164.09, the legislature provided, quote, for the availability of, quote, suits in equity, actions at law, or any combination of the foregoing. So, Your Honors, this
is where I'm having a hard time with your argument. So you're saying that language would allow them to impose a restraint on alienability?
That language just demonstrates that the legislature knew how to...
Okay, but you've already told me that some equitable relief would be okay here. So I'm just not sure how that helps you.
In this case, Justice DeWine,
you said a use restriction could be enforced in equity, even though it doesn't have that kind of language.
The use restriction is not a restriction on alienability. And
I understand, but you just read me something that talked about equitable relief generally.
Yes, to make the point, Your Honor, that if the legislature wanted to provide injunctive relief, it could have done so in this statute because it clearly knew how to do it and is aware of the longstanding precedent in this case that it must clearly describe that right. That's the point I was making. We respectfully seek that this court reverse the appeals court holding because nothing in this statute allows for equitable relief. The final point that I'll make is regarding proposition of law, point number 3, noting that the state commission, even if it deems it to have been a better notion to get injunctive relief, the state commission here cannot expand on the powers that are not given to it by the legislature. It is well settled in the state that an administrative agency only has regulatory power as it's delegated by the General Assembly. So the state is restricted or constrained to what the statute says regarding damages.
Okay, counsel, you reserved 5 minutes for Mr. Gibson at this point. Is that true?
Mr. Gibson is arguing on behalf of friend of the court, Gulfport, and I believe he has 5 full minutes. And then I've reserved 5 minutes for Mr. Honest, who will.
Yes, you're over your 10 minutes. That's my point. So we're going to let Mr. Gibson.
Thank you.
Mr. Gibson.
Good morning, Chief Justice O'Connor. Thank you, and may it please the court. And thank you for allowing me to address the court on behalf of amicus this morning. While the appellants have provided the court, we think, with sufficient grounds for reversal, we also believe that there are additional and in some respects simpler and more straightforward bases to reach that same conclusion in this case, both with respect to the enforcement of the deed restrictions and with regard to the validity of the alienation restriction itself. I'll begin with the enforcement restriction, and that is regardless of questions of statutory authority, there are 2 reasons why the deed itself and the language in the enforcement provision make it so that injunctive relief is not available in this case. The first is the liquidated damages provision, and it's specifically as it relates to the question of irreparable harm. Certainly the state is right that irreparable harm may be presumed in cases of deed restrictions, but it is only a presumption and it can be rebutted. And when a party stipulates in its contract that liquidated damages will be in fact adequate compensation at law for a breach of the deed restrictions, then that presumption is rebutted. The only other argument the commission offers is that liquidated damages and injunction are in fact complementary remedies and not mutually exclusive. But as Ohio case law makes clear, and even the cases that the commission cites makes clear, that is in the instance in where a past completed breach is being remedied by the liquidated damages, but a future potential breach is being prohibited by the injunction to avoid a prospective irreparable harm. But this is only, I would say, the secondary problem with the injunctive relief request that the commission has made. The primary problem is that of rescission. The statutory language, the commission's own briefs, and the deed enforcement provision itself all contain clear language indicating that in the event of a breach, particularly in the statute when it relates to the long-term ownership or control requirements, is a breach that can be remedied and must be remedied by grant repayment. The commission does not dispute that that is rescissionary in nature. The commission also does not dispute that a rescission of a contract means that the contract cannot subsequently be enforced by injunction or otherwise, because it is a complete destruction of the contract. It is a return of the consideration that the commission would have given for the very deed restrictions it's asking the court to enforce prospectively. And so the problem becomes what happens after the breach when a mandate from the legislature that says if there's a breach, you must seek to rescind the contract by taking back the grant money, and in fact, taking back the grant money ×2. And the answer is there is nothing left to be enforced. Once that remedy is awarded, the case is over, and the deed restrictions are in fact lifted. The money is deposited into the Clean Ohio Fund for recovered grant funds, and the commission is permitted to go ahead and utilize those to award another grant or grants. But it is not permitted to, in perpetuity, collect back its grant money 2 times that. In this instance, it would be 26 times the grant money as the bare minimum, according to the theory that the commission has asserted, and then to continue to enforce those deed restrictions ad infinitum. The practical absurdity is the outgrowth of the legal incorrectness of this view. Finally, the commission asserts, though, that it can choose then. If there's an absurdity there, it can choose between the rescissionary remedy and the remedy of the injunction looking forward. But that also is,
Council, under your proposal here, then the land goes back to Guernsey County, correct?
or it stays with Guernsey County, right, as the owner of the fee simple, correct?
Okay, all right, so it stays with Guernsey County and there's no restrictions on what they do with that land?
Correct, because a rescission of the grant would be a termination of the agreement that gave rise to those restrictions.
Okay, but they still have their deals in place with, your clients and others for
That's
the
correct.
mineral. Okay, and so the object that I'm presuming the citizens of Guernsey County sought to begin with, which was a restoration and a preservation of this stretch of land along the river or waterway, won't occur.
We would quarrel with that, particularly as it relates to the breach argument. From an enforcement perspective, if the consequence is that the deed restrictions are in fact lifted as a result of the rescission, you're absolutely right that it wouldn't be a Clean Ohio property anymore. But there in fact has not even been a breach of those restrictions, and this relates to the alienation issue. The only theory of breach that's been advanced in this case is a theory of transactional breach. There's no indication anywhere in the record or even in the arguments of the parties that there has been anything that has disrupted the actual use of the property, the surface of the property. And so what the commission is seeking to do is to take what is a draconian restriction on the alienation of property and to create what we have described in the briefing as a false conflict between the public policy of conservation and the public policy of oil and gas development. And that false conflict cannot be found in the factual record, nor can it be found anywhere in the constitutional or statutory language.
Thank you. Thank you.
Thank you, Your Honor.
Counsel, is there any argument, though, that but for the funds supplied by the Public Works Commission, which are really to further the benefits of the people and in terms of having land that's undisturbed and preserved, Guernsey County wouldn't have had the opportunity to buy this property. So is it enough to just say, smack their hand and say, okay, yeah, you still own it, you can do whatever you want to with it, but just pay us twice what you originally paid for it? We shouldn't consider anything about that?
Well, Justice Bruno, I think the legislature has answered that when it states, at least with regard to ownership and control requirement breaches, that the commission is required to seek liquidated damages and rescission, repayment of the grant. And so when the legislature made that determination, certainly there can be an honest debate about whether or not that was the proper enabling statutory language to administer the program. But at this stage, the court's only question is, what did the legislature provide for as the remedy for such a breach if one occurred?
Okay, so who could have bought this property if Guernsey County hadn't bought it with the commission's grant? Could anybody have bought this property?
I'm not entirely aware of what Guernsey County Community Development Corporation's position was, whether they absolutely needed the grant in order to purchase it or simply wanted it because they felt that it fit within their objectives. But I don't believe that there was anything regarding who could purchase the property other than a willing and able buyer, is my understanding.
Maybe somebody else can answer it as we go through the argument. Thank you.
Thank you, Your Honor.
Thank you. Thank you, counsel. Mr. Peterson.
Thank you, Your Honor. Chief Justice O'Connor, and may it please the court. The Guernsey County Community Development Corporation voluntarily sought and willingly accepted public funds. As you heard today, they accepted those public funds for the purpose of preserving certain property. And even before the Development Corporation applied for those public dollars, it knew that if it received public money, that money would come with certain restrictions. Among them was a restriction that the Development Corporation would be required to maintain long-term ownership and control of any property purchased with public dollars. And the Development Corporation knew that the Public Works Commission could enforce the grant restrictions either through legal and equitable means. All of these terms were spelled out in the clear, unambiguous deed language that was then recorded for everyone to see. Now, the Development Corporation and a variety of oil and gas companies have violated the clear and unambiguous language of the deed, and they asked the court to overlook those violations. The court, however,
why aren't the liquidated damages an adequate remedy for that violation?
Several reasons, Your Honor. First, it is a long-standing principle, both with respect to land and generally, that liquidated damages are not an adequate remedy. With land, this court has said time and again, as many other courts have said, that when you're dealing with land, specific performance is an available remedy, even when there is a damages provision. But putting that aside, liquidated damages simply do not flip the presumption of an adequate remedy. Respectfully, Mr. Gibson gets it exactly wrong when he says that having a liquidated damages clause means that there's a presumption against equitable relief. We point the court to the cases that we cite on pages 29 and 30 of our brief, where this is spelled out in great detail, and where we say that having a liquidated damages clause does not presume that you cannot receive injunctive relief. And indeed, we cite cases throughout our brief, starting with Ewing v. Davis from the 7th District of Ohio in 1903, all the way up through Messaby v. Russell and v. Boyer in the 10th District in 1992, where you have an ability to receive both.
Aren't those generally cases where the liquidated damages go to the past damages and the injunctive relief goes to the future harm? Isn't this?
Yes, Your Honor, and we would contend, and we believe that that is exactly the situation you have here. Is we are seeking prospective injunctive relief requiring a return of the property to the Guernsey County Development Corporation so that they can, in the future, maintain the long-term ownership and control that they agreed to when they sought this grant.
And do you want the liquidated damages too, or just the injunctive relief?
Our complaint thus far has requested both, and liquidated damages would be, we would have to show that there's some past harm that has occurred. So you have a question of past harm to the property, for which liquidated damages may be available, and prospective injunctive relief unwinding these title transactions. And so that is no different than any of the other cases that we've cited and that courts have found that these are complementary remedies. And there's—
Counsel, why does there have to be an unwinding of the transfer in order to, moving forward, keep the intent of with the land grants, the intention of giving the land grants? Why can't those still be monitored and adhered to without unwinding the sale?
Two reasons, Justice Stewart. One is a reason related to the deed restriction, and two is related to a statute that applies to who may receive these types of grant dollars and grant-funded property in the first place. And I'll begin with the second, which is the statute, because the General Assembly has made clear in Revised Code 164.27a that the only entities that are able to receive grant funds or hold grant funded property are local political subdivisions or nonprofit organizations. And here, there have been a variety of transfers and many private entities, as you've seen today before you, that claim an interest. And so one, you would need to unwind these to comply with that statutory requirement on how these dollars can be used. But two, it goes back to the transfer restriction itself, because not really heard much about that language of that transfer restriction, and certainly not the first sentence. And the Development Corporation, in the first sentence of the transfer restriction, agreed that the grant was specific to the grantee and that approval of the grantee's application was made in reliance on that grantee's continued ownership and control of the property. And so the agreement here is that the Guernsey County Community Development Corporation agreed that it would hold on to the property unless approval was given by the Public Works Commission. And so in that respect, injunctive relief is necessary to ensure that the Development Corporation continue to comply with the terms that it agreed to in exchange for public dollars. In this respect, the limitations—
Counsel, let me ask you about is my understanding correct that there's no surface disturbance as a result of the mining operations going on below by the appellants here?
Yes and no, Your Honor. I'll give you the yes answer first, is no activity has actually taken place. And here's the no answer. The 7th District found that the leases here authorized certain activity. They said, well, the leases authorized the drilling of wells, cutting of timber, laying of pipelines and roads, And so the 7th District invalidated certain portions of the lease. And so I know there's been a characterization that there's been no violation of the
well, if those provisions were struck, you know, that you can't surface drill, you can't cut down this timber, and you can't install roadways that are going to be in conflict with the original intent of returning this property to its natural state, you know, for the enjoyment of the community. Could that not be, there's nothing to preclude the community development folks renegotiating with the state. Is that correct?
I'll try to answer it, and if I don't answer it fully, please just let me know. Certainly, in the use restriction context, that may be true, but so there's the question of surface activity and continued use and how that relates to the use restriction. And then there's also the transfer restriction, which is broader. And the Guernsey County Development Corporation, at the time it accepted public funds, said that it would not transfer any interest in the property. And so that is not dependent on how the surface is being used. And certainly, if the development corporation had wanted to do something with this property, had wanted to transfer, the deed does allow them to come to the Public Works Commission and ask for permission to transfer a interest in the property. Now, the development corporation knew at the time it sought the grant, the publicly available policies of the Public Works Commission said that no new oil and gas leasing or oil and gas development would be permitted. But if the development corporation wanted to ask the Public Works Commission for releasing that term, it could. If the development corporation wanted the General Assembly to change the language, it certainly could. And notably, neither the development corporation nor any of the oil and gas companies here took either of those steps. They just went ahead, violated the clear and unambiguous terms of the deed, and then now when there's been enforcement, they've tried to invalidate those and avoid responsibility for their decisions. And so, you know, Your Honor, if the court has questions about the validity of the transfer restriction and the alienation restriction,
I have questions. Why we have longstanding case law that says restrictions on inalienability are invalid. Why should this case be an exception?
Your Honor, I don't think it is an exception. I think your case law is not as broad as the development corporation and the oil and gas companies suggest. The court's case law and the case law, the common law, does recognize that certain restrictions on alienation will generally be found to be invalid. And most of those apply in the context of donative transfers, testators trying to exert dead hand control. But if you look to the Ohio Society for Crippled Children and Adults decision, this court recognized that when you have an alienation restriction that is imposed for a public purpose or a charitable purpose, those alienation restrictions will generally be upheld.
Well, but there was a reason why it said they would be upheld in that case, is because you could go to a court and seek to get around them, whereas that's not really the case here.
You can go to the General Assembly in this case. So you may not go to a court, but
how can you go to the General Assembly and ask them to change a deed?
Because in this case, Your Honor, the deed is with the state. If this was a deed between two private parties, then maybe you would have a tougher argument. But when the state itself is the one that holds the interest in the alienation restriction, the General Assembly is free to say, we as the state release.
But that's the case with anyone that someone has a contract with, right? Anyone who transfers a deed, presumably you could go to them and ask them to get rid of the restriction, and that's never been considered enough.
Your Honor, I think that the difference here is, again, the purpose, the public purpose. These are public dollars, and again, the arguments that
doesn't the use restriction protect that public purpose?
It protects the public purpose to a certain degree. But as I said, Your Honor, there are two additional reasons, or at least three additional reasons. First, there's a clear, explicit statutory command the General Assembly in two places in Revised Code 164.26 and 164.23 has made clear that long-term ownership and control of these properties must be maintained. And so that alone trumps.
Well, that's not exactly.
Counsel, wait a minute.
Is it? I mean,
Go
it
ahead,
says
Judge.
shall include provisions for long-term ownership. It doesn't say there has to be. There doesn't say there has to be a deed restriction.
Two things, Your Honor. First, that's not the only provision. Revised Code 164.23 says a grant applicant must also demonstrate how they intend to maintain long-term ownership and control. And so there is the better reading is an instruction from the General Assembly. And two, even the reading that my friends on the other side offer, they simply need to adopt policies. That presumes that at some point the Public Works Commission has the authority, and maybe not in every case, but it still presumes the validity of a restriction that requires long-term ownership and control.
Counsel,
Well-
Counsel, going back to that sentence, though, that you mentioned, it says long-term control through a lease or a purchase of an easement. It doesn't talk about an alienation provision.
Your Honor, I think you could fairly characterize the deed restrictions here as an easement, and I draw the court's attention to conservation easements, which are authorized by Revised Code 5301.68. And there, when they're talking about easements, the General Assembly says these may be in the form of articles of dedication, easement, covenant restrictions, or conditions. And so I think that the term easement there is a broad term that encompasses, and in the General Assembly intended to encompass the deed restriction language here. And so I think that the deed restriction language does comply with 164.26 and its requirement that there be an easement requiring long-term ownership and control. And so I think the answer to I believe, Justice DeWine's first question that got us down this path is there's a statutory command. And the statutory command to maintain long-term ownership and control trumps any public policy that may exist with respect to alienation restrictions. Second, the answer I gave, I think, to Justice Stewart about the transfer restriction here serves the interest of 164.27a, which is it serves the interest of who is entitled to have grant-funded property and receive grants. And then the third, it's sort of an implicit reason that furthers the use restriction. And so in this case, you had a oil and gas lease, and that is a transfer of a property interest that would violate the deed restriction unless the Public Works Commission approved it. And as I said, that oil and gas lease violated the use restriction, which is why the 7th District invalidated certain portions. If the Public Works Commission had been given an opportunity to review that at the outset, it could have prevented any transfer that authorized surface use and would have eliminated the need to go to court to protect this property. And so there is an implicit benefit here of requiring restrictions on alienation, requiring approval before alienation, because it does advance, at least implicitly, the public use restriction that, again, the Guernsey County Development Corporation agreed to in exchange for these public dollars.
Mr. Peterson,
yes.
when I look at the Ohio Society for Crippled Children and Adults, again, part of its focus is that it's for a charitable or a public purpose, and that the inalienability of the land is to sort of maintain that charitable or public purpose. Now, a community development corporation could be definitely a nonprofit, or it's a non-governmental organization connected to the county, but it's a development organization. So was it appropriate for the Public Works Commission to grant those funds to the Community Development Corporation when it seems like by its purpose, it's going to do something to try to develop the land?
Your Honor, the Development Corporation doesn't necessarily have to develop the land. Certainly, it could be envisioned that could develop the community by attracting tourism through a park. Here, what they sought to do is they sought to protect the riparian corridor and protect the Leatherwood Creek stream. And so this is part of a whole larger project. And so I don't think that simply because development is in the Development Corporation's name, that they would necessarily be limited to developing the land in the way of building or constructing on it. The development can take a variety of forms.
Thank you.
Justice Bruner, I did want to answer a question that you had asked earlier about the funding and the purchase of this property. My understanding is when the property was available for purchase, anyone could have purchased it. And here the state provided 70% of the purchase price. And that, when I say 70%, that could even be a greater percentage of the dollars, because there's a limitation on how much funding someone can receive from a Clean Ohio Conservation Fund grant. And you can have an in-kind contribution. So here we know the state provided at least 70% of the purchase price, and that doesn't necessarily mean that the other 30 came in dollars. It may have come in in-kind contributions, and that I cannot answer, but I know you had asked that question earlier.
Thanks. Yeah, that's pretty typical with grants and nonprofits. Makes sense. Thank you.
And I see my time is running a little short. I just wanted to briefly touch on the rescissionary argument and any other questions the court may have related to the injunctive relief. I already explained why the basis of the status of the law is simply having a liquidated damages clause does not mean that you cannot seek injunctive relief. And we think that nothing the General Assembly said in Revised Code 164.26 changed that. In fact, the General Assembly would have needed to prohibit injunctive relief if it wanted to, as the court has said time and again. I know Justice Kennedy, you noted this in a recent concurrence, that the General Assembly is presumed to know the status of both the common law and the statute law and needs to be explicit if it wants to change that. And so we think that the General Assembly would have needed to explicitly prohibit injunctive relief rather than authorize it. But turning to the rescissionary question, this wasn't a rescission of a grant, this was a breach. And as we've already discussed, the measure of damages doesn't mean that that is an exclusive remedy. And even that argument fails on its own terms if you look at 164.26, because if this was a rescission, you couldn't get liquidated damages. The idea of rescission is that's all you get, is you get your money back. But the General Assembly says you get both liquidated damages and grant repayment. And so that's best understood as a measurement of damages, not as authorizing some sort of rescissionary remedy. And so for these reasons, because the deed language is clear, no one has argued that there is any ambiguity, because it's authorized by statute, we think that the court should hold that the transfer restriction is valid. And then we think the deed language is again clear with respect to injunctive relief, the status of the law, both with respect to specific performance regarding land, many courts, many cases from this court and others, and the many cases holding that an injunctive relief is still available in liquidated damages. We would ask the court to hold the transfer restriction.
How would that work? The point of having liquidated damages is so a court doesn't have to do a damage calculation, but you're saying that you could have equitable relief going forward, but still liquidated damages to compensate for the past harms. How would you calculate what those liquidated damages were?
Your Honor, I think that is the essence of, like you said, liquidated damages exist so that the court does not need to calculate it. I think you would have to show some damage. You have to show the property was changed in some way, whether it's on this, whether the property interest.
So that there'd be no bar to them getting a double recovery for the state then?
I think that is an argument. I mean, certainly, as we said in our brief, the courts haven't faced this argument.
Tell us what you think, that if we bought your argument and remanded it, what a court would do on remand as far as calculating liquidated damages for the state and fashioning equitable relief.
I think the first step, Your Honor, would be once you unwind the transactions that violated the transfer restriction, taking a look at the property. And that would be looking at two things, looking at the surface of the property, was that changed in some way? And then just looking at the whole of the property interest. Was the property interest that was conveyed back to the state the same as the property interest that existed before any of these violations occurred? And I think the state would first have to show that some damage occurred in either one of those contexts.
Counsel, so they showed some damage occurred. Would they get the full amount of liquidated damages, or?
Your Honor, I don't want to prejudge our arguments. In this case, I'd like to remind the court, before anything happened, the trial court held that we could only seek liquidated damages. We couldn't seek injunctive relief. And then immediately,
I think if you want both, you got to explain how that would work, because.
Well, Your Honor, I think that I've explained that we would have to show the damages, that the property was damaged. And if we can make that showing, then we can seek the liquidated damages to which the parties agreed in exchange for public dollars. This was a contract. It was an arm's length transaction between the Community Development Corporation and the state. The Development Corporation agreed to certain terms. And so at the very least,
the state would come out way ahead. They get a lot more than they get the property back, and they get the liquidated damages amounts.
I don't know that I could say, Your Honor, whether the state would come out ahead or not, because if the state cannot prove damages, if the state cannot prove that any damages occurred, then all they would get would be the property back. But if they can prove that the property was damaged, then the state would get that
doesn't sound like liquidated damages at all. That sounds like some kind of actual damage calculation.
Well, I don't know if that's necessarily right, Your Honor. Maybe it is closer to an actual damages calculation if you were trying to show what the value of the damage is. But here, all I'm saying is that you would have to show damage. Whether you don't necessarily have to show the value of the damage, but in order to invoke liquidated damages, you would at least have to show that the property was damaged, which would mean, is the state getting back that which it originally paid for?
Counsel, that goes to my question about you don't like rescission, it sounds like, and yet you're asking for equitable relief with an injunction. Aren't you required to do equity to get equity?
I guess I'm a little confused.
Well, I'm going back to jolly old England and early American law, where to ask for an injunction from the chancellor, you have to agree to do equity. And rescission is an equitable remedy. So how can you get an injunction without and say we don't have to do rescission?
I guess I would point to the court to the cases I cited earlier, and I don't know if this is adequate to answer your question. But in the Ewing v. Davis case and the Messi v. Russell case, you had a forward-looking injunction, and you had a backwards-looking damage, and so that's not a rescission. That is simply damage for past harms that have occurred, an injunction to prevent future harms. And that's what we're asking for here in this case. That's not a rescission. That is simply stop the harm and abide by the restrictions you agreed. And then if there are damages for past harm, we should receive damages for past harm that has occurred.
From what I hear then, you're asking going forward, forget the past damages, okay? You're asking us to enforce the contract, but you don't want to have to go back to the beginning of the contract and give them back rescission.
I guess I don't. I think we may be talking about rescission and who gets what back. We paid money to purchase this property in exchange. The Development Corporation agreed to certain terms. What we are asking is that the Development Corporation going forward be held to those terms. And I don't see that there's anything necessarily that we would need to return. All we are doing is seeking to enforce the arm's length terms to which the Development Corporation.
So the state does not get this property back, as was mentioned by, I'm not sure who, under a scenario that the state would get twice the liquidated damages by a showing of damages, plus get the property back. The property at the end of the day would stay with Guernsey County or this development corporation. They just have to abide by the terms of their original contract.
Yes,
that's what you're asking for.
Yes, that's what we're asking for. Exactly, Your Honor.
Okay.
And so I know I'm over time. I'm happy to entertain additional questions. But for the reasons that we've given today and the reasons in our brief, we would ask the court to affirm the 7th District, hold that the transfer restriction is enforceable, and that at least with respect to forward-looking, an injunction is available to enforce those terms.
Mr. Peterson, before you go, can I ask this question?
Sure.
You want a green space along the river. it's a reclaimed strip mining facility, and let's say the green space is there remaining intact for the public to use. But what if the platform for oil and gas collection is not on the green space, nowhere within the property, and they're able to access and produce minerals and oils as a result of it somewhere off that and without violating your contract? Then what do you say?
I'd say two answers, Your Honor. I think there's an answer based on the use restriction and the transfer restriction. And we would agree that that would not violate the use restriction. It would, however, violate the transfer restriction because an oil and gas interest is an interest in the property, and transferring that away would violate the transfer restriction. Now, if that becomes an issue, the General Assembly is free to adopt policies or adopt statutes that authorize that type of activity. In fact, that's what the General Assembly did when it created the Ohio Oil and Gas Leasing Commission. It created a process by which state-owned land could be leased for oil and gas development. And so if the General Assembly, if oil and gas companies, if community development corporations wanted to go to the General Assembly and say, here is all this land, we can't transfer it away because of the terms of the Clean Ohio Conservation Fund, we would like you to create a process by which we could access that, you could waive the transfer restrictions because it's held by the state. They're free to ask the General Assembly to do that. What they're not free to do is simply disregard the plain language of a contract to which they agreed. Again, they didn't ask the General Assembly for permission. They didn't ask the Public Works Commission for permission. They're just here trying to invalidate a contract in the plain language. And so I hope that answers your question. Happy to answer any follow-up, but if there are no further questions.
Thank you, Mr. Peterson. Thank you.
Thank you, Your Honor.
We will return now for rebuttal by Mr. Onest.
Madam Chief Justice, and may it please the court, we are dealing with a single sentence about what remedies are available to the Ohio Public Works Commission for violation of long-term ownership and long-term control restrictions. And the legislature has said those are liquidated damages and grant repayment for any failure to comply. Now, our questions are, does the Ohio Public Works Commission fall within that authority, that limited authority that it is given by the General Assembly when it demands a deed restriction which permits it to seek equitable relief? The answer is no. It acted outside its authority. Two, does the Ohio Public Works Commission act outside its authority when it asks a court for equitable relief? The answer is yes. It acted outside its limited power. The Ohio Public Works Commission has it backwards. It is not about what the General Assembly may not have said. It's about what it did say. And it did say, set your policies for long-term ownership and control. And if there is a violation or a breach, you provide for monetary relief. That is the limit. General Assembly has spoken, and that's what we have to apply the statute as it's written, limiting remedies to money. And so for that reason, we have to overturn and reverse the 7th District and reinstate the trial court's decision. And Justice Kennedy brings up the green space issue. There is no indication in this case that there's any sort of use restriction violation or that the green space is being threatened. In fact, I believe the producers in this case are indicating that the green space will be maintained to the best of everyone's ability and that there's not going to be any surface use for this property.
Mr. Onest?
Yes, Your Honor.
164.02 and .05 authorize the Ohio Public Works Commission to, quote, do all other action, enter into contracts, and execute all instruments necessary or appropriate to carry out this chapter. Why wouldn't that, under that umbrella of do all other action, include seeking an injunction in equity?
Your Honor, so first in Revised Code 164.26a is a specific statute talking specifically about the remedies that the Ohio Public Works Commission may impose. That specific statute would control over the general statute that you're talking about. The court, and we cite to the DABE decision, I refer to it as the DAB decision, there was a grant to local public health boards at the county level to do all things necessary to promote public health. So what do? They put in a general smoking ban. Well, this court said, even though you're allowed to put any regulations which are necessary for promoting public health, power is not absolute. So when you look at the fact that power cannot be absolute with an administrative agency like this, and then you couple it with the specific statute which governs the remedies that can be imposed, negotiated, and sought, you have to apply that specific remedial statute because it is clear on its face. The policy shall provide for proper liquidated damages and grant repayments for those failures. So the specific controls over the general, Your Honor. I know I'm over my time allotted here, Your Honors, but all I would say is that in closing, the monetary damages that could be sought in this case are significant. We're not talking about low sums. Undoing the transactions does not further the Clean Ohio Fund here. There is no indication that any sort of green space is going to be violated. And for those reasons, and for the reasons discussed earlier, we believe that the 7th District's decision should be reversed and the trial court's decision should be reinstated.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision. Our last case this morning is 2020-0091, State of Ohio, ex-rel David Yost, Ohio Attorney General versus Rover Pipeline, LLC et al. For the appellant, Mr. Flowers.
Thank you, Chief Justice O'Connor. May it please the court, I'll reserve 3 minutes for rebuttal. This case presents 2 questions. Today, I plan to focus on the first, which involves the consequences of a state's failure to timely act on a 401 certification request. And frankly, on this issue, there's more agreement between the parties now than there is disagreement. Rover does not defend the 5th District's holding below that the consequence of a waiver is that a state may never enforce any water quality law against a federal permit holder, even in response to pollution beyond the scope of the federal permit. So the dispute at this point boils down to what rule ought to replace the one the 5th District announced. So let me start there with our rule, which has 2 parts. The first defines the waiver. The second defines the consequences. The waiver itself is a waiver of the right to participate in the process, in the federal permitting process. And that follows from the text of 401, which the only time it speaks about waiver is when it says that what's waived are the certification requirements with respect to the federal application. The certification requirements are simply the obligation to consult with the state during the permitting process. So that's the waiver itself. What are the consequences of that waiver? Well, the rule that we propose in our briefing is the same rule that Rover itself suggested in footnote 7 of its 5th District brief. A state that waives the right to participate cannot enforce state law in response to discharges that were anticipated by the federal permit, but it can continue to enforce state law in response to discharges, I'll just quote from their brief, that go beyond the scope of those anticipated by the federal permit.
Is that the argument you made below?
It is not the argument we made below. When we came up here, we narrowed the argument. Previously argued that there was no restriction whatsoever on what the state could enforce its power with respect to. And candidly, we've concluded that that's not the best argument. And so came up here with a narrower version of the argument we brought below, which is that we can punish them for at least some of the violations alleged, including in particular, the discharge of drilling fluid that was laced with diesel fuel. And that's actually a good opportunity to connect the rule.
Isn't the scope of the permits to cover discharges? I mean, isn't that what you waived?
No. So if you look at the text of 401, the only thing you waive is the right to participate in the process. But as far as the consequences go, what we've waived is the ability to to punish violations that occur with respect to the project as it's described in the federal permitting process. We obviously can't anticipate projects that are implemented or carried out in some completely unforeseeable way. So to take an extreme example, Rover here throughout the permitting process said that it would use water and non-toxic bentonite clay in its drilling fluid. That was what it said it was used, and that's what we were presented with in the process. Let's suppose that instead of, let's put diesel fuel to the side. Let's suppose that they said, you know what, It's cheaper for some reason. Instead of using diesel fuel, we'll use massive amounts of radioactive waste, no water or clay at all. Even they would concede, I would hope, that that's beyond the scope of the federal permit because it's completely unanticipated by the federal permit. So what we need to ask in this case is whether the discharge that occurred here, allegedly, and remember, we're still at the motion to dismiss stage, so we have to assume the truth of the well-pleaded allegations. The discharge here involved a discharge of drilling fluid that contained water, the non-toxic bentonite clay. They said they would use that laced with diesel fuel. There's nothing in the federal permitting process that described the project as containing that. And so the state did not give up its authority to enforce state law in connection with that discharge. To maybe put a finer point on it, I can talk a little bit.
Counsel, what would the federal government do with a breach like that?
With a breach like the one that actually occurred?
Yeah.
Well, to our knowledge, there's been no fine at all. They did oversee the cleanup, but of course, a key part of our
they halted the production, if you will, and the operation, and forced them to do cleanup. Correct.
Correct.
Is the issue of a fine off the table?
I don't know that it's off the table, though it wouldn't be up to us. And that's the key point here. It's not that the federal government couldn't do anything. It's that the states in our form of government are not obligated to depend on the federal government to defend their citizens and their rights for them. But let me, to maybe draw a little bit of a distinction between anticipated discharges and unanticipated discharges. Let me talk about some of the things that one thing at least that we did waive, or I should say that we can no longer enforce our state law with response to. The permitting process, no doubt, disclosed a risk that there would be a risk of inadvertent returns, which means the drilling fluid comes to the surface. And so with respect to the inadvertent returns that involved nothing but the water and the non-toxic bentonite clay that they said they would use, we at this stage now concede that the state cannot enforce its laws with respect to that. But if Rover had laced, again, its drilling fluid with radioactive waste, or human waste for that matter, or diesel fuel, that's beyond the scope of what they ever suggested could occur in the course of the project. So it's not the project, it's not the activity with respect to which we made any waiver at all. Now, in addition to that discharge, which is sort of the main discharge at issue here, we also have in count 6 of the complaint an allegation that Rover violated the terms of a hydrostatic permit it obtained outside of the permitting process. Let me explain why that count is also valid, at least at the motion to dismiss stage. Again, the waiver is a waiver of the right to participate in the process. It's not a waiver of a right to do anything ever in connection with the federal permit holder, and it's certainly not a waiver of the federal permit holder's right to engage in outside agreements. So let's say that instead of a hydrostatic permit from the state, Rover had entered into a contract with a private landowner in Ohio in which it agreed to all of the terms of the hydrostatic permit and said, we'll follow those terms in exchange for some sum of money. If that had occurred, it's beyond dispute, I think, that would be a valid contract. And just as the federally regulated party can agree to terms that go over and above what federal law requires with the private party, it can agree outside the process to new terms with the state. Doesn't mean the state can unilaterally impose those terms. That would be a different case. But if they independently agree to abide by these terms outside of the process, the waiver of the right to participate in the process simply has nothing to do with it. And what I want to stress, going back to the rule we're suggesting here, as I noted, as we've honed our position as we came up, it is a rule that was at least suggested by Rover, again, in footnote 7 of its 5th district brief. You can also look at footnote 13 of its motion to dismiss, where it said, we want to be clear, the state doesn't give up its ability to enforce state law in response to discharges that were, quote, not contemplated. Well, it was never contemplated that they would add diesel fuel to their drilling fluid and inject it right below the highest quality wetlands or some of the highest quality wetlands in Ohio. That's what's alleged to occur.
I guess what I'm having trouble with is that it seems to, as I look at the statute, what the certification is about is a project. And it seems the state waived its ability to attach conditions to this project, including that they comply with state laws. So I guess the problem I have with your argument is I don't understand how the court would ever go through and figure out what was anticipated and what wasn't anticipated? It seems like a completely nebulous kind of inquiry.
Well, let me answer in reverse order. In terms of what the court would look at, it would look at the filings made in the federal application, and it might have to hear from experts, but oftentimes it can look at that and see what discharges were disclosed as a risk.
Isn't the point of having conditions is to preclude, is to prevent harm from stopping that goes beyond what's anticipated? That's why you attach conditions that you do certain things, because you don't always know what might happen.
No, to the contrary, the state's role in the certification process. So even if it issues a certification, its role in that certification process is to impose conditions or not on the project as described. You asked sort of what is the project? That's really what this comes down to. The project doesn't mean anything that carries out the end that they seek. For example, building a pipeline. Even they concede, I think, that if you were to use pure radioactive waste as drilling fluid, that would not be the project at issue here because it wasn't the project as described. I can give you some statutory hooks for this understanding of the state's role. The first is to remember the default rule. Under both Ohio law and the Clean Water Act, all discharges are prohibited until they're affirmatively permitted. So if in the permitting process, they don't come forward and say that there's a risk of a certain thing happening, the permit doesn't allow that and it remains illegal. But I can also point you to 401A3 of the Clean Water Act. What that statute says is if the state issues a certification, the certification is valid not only for the federal license in connection with which it was sought, but also for future federal licenses. But there's an exception. If the construction or operation of the facility changes, in other words, if the project with respect to which the certification was issued is not the same project that's actually being implemented because something about it changed, the certification is no longer valid and the pipeline or the federal permittee has to get a new permit. So that shows, again, that the focus of the state's role is on the project rather, as it's described, not every logically conceivable iteration of the project. And if there's any doubt about that, I think you have to read the consequences in light of the bond principle. Again, 401 does not say anything about the consequences. When we talk about the consequences, we're talking about what we can infer from the statutory structure. If Congress had intended to tell the state that you lose, as the 5th District said, literally all of your authority to go after the federal permit holder for any pollution that occurs in connection with the permitted project, it needed to say that expressly. That's a massive loss of sovereign power, but there's nothing expressed in the statute that says that. And our federalist system requires that we read the statutes to preserve state authority. And indeed, the Clean Water Act is about, I'm sorry.
Don't the appellees sort of tacitly recognize that it's based on the project when they modified their plan and received a new certification because of alterations to their original plan?
I think at the time, yes, they recognized that that was a different project. And again, maybe they can come up here and explain why, if they had used radioactive waste, that would still be covered by the permit. I don't think they can. I read their brief to give away that much, but if they give away that much, what we're left with is the rule they suggested in footnote 7 of the 5th District brief. The state retains its power to enforce state law against unanticipated discharges. If I can make one thing clear about, I'm sorry.
Counsel, that does not have to be spelled out in a certification process. That the state retains its sovereign rights, for any purpose at this point. Maybe not, what you're describing is the limited contents of the certification process, and the state missed out on participating in that. But as you're saying, there can't be a blanket denial of the state's sovereign rights just because there's this, certification process that is gone through.
I completely agree with that. That's exactly the argument we're making, is that if Congress wanted that to be the consequence, or it needed to say so expressly, and it simply doesn't. I see my time's running short.
Well, then my point is every certification project or the certification process does not have to explicitly say, oh, by the way, Ohio gets to retain its sovereignty with regards to its statutes.
Correct. We're not required by the Clean Water Act to do that. And in fact, the Clean Water Act, if you look at 33 USC 1370, expressly says It does not interfere with the state's right to regulate water quality as long as they do it in a way that's consistent with federal law. Before I sit down, I'll just quickly make the point. With respect to anticipated versus unanticipated, keep in mind we're still at the motion to dismiss stage. So there will be a chance for them to say that, in fact, this was disclosed somewhere. They haven't showed where that is here, where that occurred, but maybe they can do it on remand. That would be a question for later. I know there's also a second question. We think our briefs adequately address those arguments. I'm happy to take questions, but otherwise I ask to reserve the remainder of my time for rebuttal.
Thank you. You've saved about a minute and a half. For Rover Pipeline, we first have Mr. DeBold. Council, you'll have to unmute yourself.
Sorry. Chief Justice O'Connor, and may it please the court. Mr. Knoth, counsel for Laney, will be using 2 of our 15 minutes. The issue in this case is not whether water pollution will be regulated, but who will regulate it, and in a very narrow context. First, you're only dealing with federally licensed activities that could result in discharges to a state's waters. And even there, we are only dealing with a situation where a state chooses to take no action within 1 year of a water quality certification request, which 2 courts of appeals have held means that the regulation of the project as a whole returns to FERC for its plenary authority, which it has in the first place under the Natural Gas Act. Congress put complete authority over natural gas pipeline construction in a federal agency, and it gave states ample time to participate in establishing the rules of the road that would be relevant to water quality before construction begins. Every lawyer knows that time limits on which to act in a filing or otherwise are very important, and that failure to comply with them can have serious consequences. But those consequences are not serious in this case, because if a state does not act within 1 year, authority remains in FERC's hands to set and enforce environmental conditions, which is exactly what happened in this case. The state, recognizing that it was FERC's decision how to handle these discharges, turned to FERC when the discharges occurred and asked FERC to issue a stop work order, which FERC did. It also asked FERC to require remediation, which FERC again did, and Rover has spent tens of millions of dollars remediating the discharges at issue in this case. FERC also changed the conditions and terms of its license by adding further requirements, such as hiring an independent third party to review the methods that were being used, a doubling of environmental inspectors, the change in the drilling to go deeper beneath the ground, and multiple equipment modifications that were designed to and did detect and prevent larger inadvertent returns. Only after FERC was satisfied and the state indicated its satisfaction with these various measures did FERC allow the work to resume on these types of activities. And that is exactly the way the process works when you have a federal license and the state has an option, not an obligation, but an option to participate in the process. The state's proposed rule, which it newly argues in this court, and frankly, it's hard to fault the 5th District for not commenting on this version of the rule, because in the 5th District, the state took the position that only discharges of fill material, which fall within the jurisdiction of the Army Corps of Engineers, are affected by a waiver under 401, which is why the 5th District did not address the argument that the state is raising here. But be that as it may, the state's proposed ruling here, or proposed rule here, would basically require, would allow a state to come in after the fact at a time when only FERC may set conditions on a license and add conditions to that project after the project has already gotten underway. The way the state is supposed to participate in the certification process is not simply to say, we want you to follow all of our laws. What the state does in the certification process, it makes a cost-benefit analysis. What effects on water quality is the state willing to accept? In this case, the state, when it issued its untimely certification, said that the lowering of water quality in 11 watersheds was acceptable because of the nature of the project and what it wanted the project to accomplish.
But you're saying that because the state didn't certify within a year, you're saying that's what basically was the state's belief?
that when the state didn't act on the certification within a year, it had a choice of either denying it, which would have halted the project, or it could have granted it, including with conditions. And if the state had participated in the process and set conditions, then we would not have the waiver issue that's before the court today.
Understand, but what this difference between the activity and the project, the project is as defined in whatever FERC certifies in the end, whether the state's participated in that process or not. But if it steps outside of that project, you're saying the state still can't step in and enforce its laws?
There's a distinction between the activity that's licensed by FERC and that FERC has authority over, and that activity is the construction of a natural gas pipeline. There's a distinction between activity and the word discharges. And what the state does in its reply brief is it conflates the two, when clearly the statute is designed to make sure that when a license to conduct activity, and I'm quoting from 401A, when a license to conduct an activity, such as construction of facilities, is applied for, then the applicant has to go to the state and seek a certification that the activity, to the extent it may result in discharges, would be in compliance with state's environmental laws, water quality laws.
I understand, but activity and project, you're interchanging those words, am I right?
And for good reason, because the activity that's referenced in 401A is the construction of the facility that is subject to the federal license. The Supreme Court addressed this issue directly in subsection 401D, where a state wanted to add conditions that were not directly tied to the discharges that the applicant raised when it submitted its application. And the Supreme Court said the scope of the conditions that are covered under 401D, which have to go into the certification if the state finds them to be necessary to protect water quality, the scope of those conditions is broader than the discharge that may have been disclosed by the applicant. The Supreme Court said that this is at pages 711 to 712 of the Public Utility District number 1 case that we cite in our brief. Section 401A identifies the category of activities subject to certification. And 401D is most reasonably read as authorizing additional conditions and limitations on the activity as a whole once the threshold condition, the existence of a discharge, is satisfied. So just as a state that participates in the process and decides that it wants to act within 1 year shall include in the certification all conditions necessary to comply with the Clean Water Act and with other applicable state requirements, the state that doesn't participate in the process has given up the opportunity to set those conditions.
But I understand one more thing. So, but the application that goes to FERC and that FERC approves, it's pretty lengthy and it's descriptive and it's going to be specific. So if an applicant, even after they're certified, sort of changes course and does it differently, have they stepped outside of that activity or that project? Because it was certified to be done in a certain way.
So it turns on what the scope of the federal agency's jurisdiction is. And here there is no question that FERC has authority to bring action when there is a discharge that occurs that is outside the scope of what FERC anticipated. And in fact, in this case, FERC has an investigation that's been pending since 2017, specifically based on the discharge of the inadvertent returns that contain diesel fuel. And that is referenced in the September 18th, 2017 letter that is cited in our brief, where FERC gave permission for the project to go forward and reminded Rover that there was still a pending investigation of the discharges that resulted in the diesel fuel being detected. So clearly it's within FERC's jurisdiction. FERC has the authority to enforce violations of its permits, of its license, of its conditions. What the state is seeking to do here is come forward and say, we think you violated the conditions of the FERC license. Therefore, we are going to start enforcing our laws in response to that. And it creates a lot of real administrability problems because, for example, the FERC license has conditions that require certain things to be reported within a certain period of time. FERC takes the position that if there's an inadvertent return, it has to be reported promptly. There has to be a coordination effort for how to respond to it. There has to be remediation and so forth. Under the state's view, if the applicant, if Rover in this case, missed the timing to report the inadvertent return by an hour or 2 hours, that would mean we're in violation of the permit by FERC. We have no longer done a discharge or done activity that is within the scope of the license. And the state can come in and enforce a law that applies to any discharge without a permit. That's the way the state laws are written. So that means that the state would then be enforcing this law that is not tailored to the circumstances here.
What about that? That's your kind of extreme hypothetical. What about Mr. Flowers' hypothetical about started using radioactive waste for the project?
It would turn on whether, it would turn on whether the discharge at issue there was within the scope of the carrying out the construction activity, building the pipeline. And it would also turn on whether FERC would have jurisdiction over that particular activity, because FERC is the one that issues the license.
Okay, well, now, say it was used in building the pipeline.
FERC would then take action against that discharge, because FERC is the agency that has jurisdiction when a state returns its delegated authority back to FERC by not acting within 1 year on a water quality certification request. That's how the line gets drawn, and it's a way to make sure that one way or the other, the discharge is subject to regulation, subject to remediation, which occurred in this case with the kinds of discharges the state was arguing here.
Council, under this scenario, we have a radioactive discharge. I thought I heard you say that if there was a radioactive discharge, that would be exclusively under FERC because of the nature of the activity that precipitated that discharge. Is that right?
If it meets the definition of being something that occurred while carrying out the construction activity that was licensed by the federal agency.
Okay, so if Rover was not licensed to use that radioactive agent, that's FERC, right?
FERC would, if it used a material that was not disclosed to FERC, which is the basis for the investigation involving the diesel fuel.
Right.
FERC is asserting that you said you were going to use bentonite in water. You never told us about diesel. Now we're investigating that because it's beyond the scope of what we authorized. Okay. That's why it falls into FERC's hands.
All right. If Ohio had not missed the deadline for certification and the scenario came up where there was radioactive discharge that was not disclosed as part of the initial application for certification, who would FERC still be responsible for what what they do with that discharge, the remediation and whatever consequences are meted out to Rover?
FERC still acts in the first instance. Then there would be a question about,
does the state have any rights under that scenario?
There are two arguments that were made in the trial court, but not considered by the by the 5th District. One of them is a different preemption argument, and the other one is that improper collateral attack argument. And those arguments would be available to appellees on remand if the court were to reverse. Very briefly, the collateral attack argument essentially is that when a state asks FERC to take action in response to pollution, and FERC refuses to take the action that the state requires, the proper remedy for the state is then to appeal to a federal court of appeals. There's a specific provision in the Natural Gas Act that applies here. It's not a Clean Water Act argument, it's a Natural Gas Act argument. So there is that separate argument that we would have to litigate as far as what happens in a case where the state does comply with the 1 year time limit and does set conditions on its certification rather than just giving a blanket certification.
Okay, thank you. We're down to the 2 minutes that you've reserved for Mr. Knopf.
I will reserve those for him. Thank you.
Before Mr. Bowl leaves, can I ask one?
Sure.
I'm struggling to understand. I understand your argument about the diesel fuel, but I'm struggling to understand the permit argument. It seems, as I understand it, FERC says you have to get the state permit. They go to the state, they get the permit, they agree to be bound by the state's conditions of that permit. It's a condition of getting it. That's certainly post any waiver, I guess. Why could the state enforce that?
There is a timing issue here that I think that the state elides, and that is that the requirement by FERC for Rover to get the hydrostatic test water permit. That condition was put in the environmental impact statement, which was issued in July of 2016, which was about 4 months before the Ohio deadline for acting on the water quality certification ran out. So FERC included that, and it also included that we had to get a 401 certification because, again, we had four months waiting for Ohio to act on that. So it was an anticipation of the state participating in the process, which the state had already been participating, and there was no reason to believe it wouldn't. When the state then waived by not acting on the certification, the requirement, to the extent it applied, is a requirement that FERC enforces pursuant to the license, because it was.
But the state didn't waive its right to enforce its permit, did it? I mean, there was no, that would seem a separate. I mean, once they'd applied for a permit, it would seem like that would require some kind of separate waiver from the state.
Well, the permit requirement only existed because FERC required it as a condition of its license. And so it remains to FERC whether or not to enforce or take action with respect to any activity that is perceived to be beyond the scope of the hydrostatic test water requirements.
Thank you.
If there are no other questions, we ask that the court affirm.
Okay, Mr. Knopf, I'll give you 2 minutes.
Thank you, Your Honor. My name is Tom Knoth, and I represent Laney Directional Drilling. I'm also speaking on behalf of 3 other contractors that are Appellees: Atlas Trenchless, B&T Directional Drilling, and Mears Group. We are arguing separately to explain that these 4 contractors prevail even on the state's new limited waiver argument. And interestingly enough, the state made a concession in its argument that because of this limited waiver, that it cannot enforce state laws against just discharges of bentonite clay and water. And as it turns out, all the claims against these 4 contractors in the third amendment complaint alleges precisely that they had inadvertent returns or discharges of the very same drilling fluid of non-toxic bentonite clay and water. There was no allegation that these contractors discharged anything like diesel fuel, and there's no claim against them that they violated the terms of a permit. So given the state's concession and given the fact that we believe the state has waived its delegated authority under Section 401 by not acting within 1 year after it received the certification request, we believe, given all this, that the court should affirm the judgment below, dismissing all the claims against Laney, Atlas, B&T, and Mears, because the state can no longer regulate those discharges. That's all I have. If you have any questions, I'm more than happy to answer them.
Thank you.
Thank you very much. Appreciate it.
Thank you. Mr. Flowers.
Thank you, Chief Justice. I have 4 quick points that I'll try to get through in my limited time. First, my friend on the other side referenced the fact that this is a federally licensed project. To the extent he's invoking the Natural Gas Act, it's irrelevant here. 15 USC 717B subsection D says that the Natural Gas Act does not preempt. It shall have no effect on any of the state's rights under the Clean Water Act. One of the rights under the Clean Water Act are not only the delegated rights that they talk about, but also the inherent rights, because 33 USC 1370 preserves the state's inherent authority to regulate water. Second, Rover said that the test here is unadministrable. That's a strange suggestion, because the test I suggested was literally quoting from the brief they filed in the 5th District. Footnote 7 of that brief, footnote 13 of their motion to dismiss. With respect to the role in the process, Rover suggests that the state's role is just to determine what effect, do a cost-benefit analysis and determine whether the potential costs are worth the potential benefits. Well, that just shows why our test is right. We can't do the cost-benefit analysis if they don't disclose all of the potential costs. And at least at the motion to dismiss stage, the release of diesel is potentially so far beyond what was discussed in the permitting process that there's no waiver as a matter of law. Finally, they suggest at length, both in their brief and here, that we don't really need to worry about this because FERC can regulate it. Well, as an initial matter, FERC might not regulate it in some future case. But the most important point is that Ohio is a sovereign state. We're not a conquered people who have to look to the federal government to defend our interests. Unless Congress expressly takes away our power to do so, it has not done so. And there's nothing in the Clean Water Act that takes away that power. To the contrary, 33 U.S.C. 1370 preserves it.
Do you have any response to Mr. Noth's argument?
I do. He's correct that we're no longer seeking relief on the discharge of water and non-toxic bentonite clay, but they shouldn't be dismissed at this stage because the complaint makes clear that we have alleged that the parties are jointly and severally liable. Now, on remand, they could argue that they're not jointly and severally liable, but they haven't made that argument here.
Thank you.
Thank you.
Thank you. We will take the matter under advisement and you'll be notified of our decision. Thank you, gentlemen.
Thank you.
Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.